You're sitting on the shoulder of the road, hazards clicking, and the officer leans down to your window and says the 4 words that should make your stomach drop. We're impounding your vehicle. Maybe it was a busted taillight. Maybe your registration lapsed. Maybe it was nothing at all except a hunch. But now, before you even know what's happening, that officer is telling you they're going to tow your car and inventory everything inside it. If you don't know what to say back in that exact moment, you could be handing them a legal excuse to dig through every bag, every glove box, every locked case in your trunk. So today, as a former prosecutor who now spends my career fighting for people just like you, I'm going to give you the exact phrase to say the second an officer tells you they're inventorying your car. And I'm going to break down exactly why this so-called inventory search is one of the most abused loopholes in American policing. Let's get into it. First, you need to understand what an inventory search actually is, because the police are counting on you not knowing the difference between this and a real search. Roughly 50 years ago, the United States Supreme Court decided a case called South Dakota v. Opperman. And in that ruling, the court said police are permitted to conduct a routine, standardized process of logging the contents of a vehicle once that vehicle has been lawfully taken into police custody. Notice what that says and what it doesn't say. It does not say police can search for evidence. It does not say police can go looking for contraband. The entire justification the Supreme Court gave for allowing this exception to the Fourth Amendment was property protection, not crime fighting. The idea is simple. If your car ends up at a tow yard, the department wants a record of what was inside so nobody can later claim an officer stole their watch or their cash. That is the only legitimate purpose. The moment officers use this process to hunt for drugs, weapons, or anything else that could be used against you in a courtroom, they've stepped outside the boundaries the Constitution allows. Here's how the loophole plays out in real life, and if you've ever been pulled over, this might sound painfully familiar. An officer stops you for something minor, maybe a cracked windshield or an expired inspection sticker. Somewhere in that conversation, they get a feeling that something isn't right. Maybe you seemed nervous. Maybe there was an odor they claimed to notice. Maybe you simply didn't answer a question the way they wanted. They asked to search your car. You say no, and now they're stuck. Because without your consent, without a drug dog alerting, and without probable cause, the Fourth Amendment says they can't put a hand on that vehicle. So what do they do instead? They start looking for any reason at all to justify towing your car, an equipment violation, an expired tag, even just a department policy that gives them discretion to tow instead of letting you drive away. And once that car is being towed, they suddenly have the authority to inventory everything inside it. In other words, they use the tow as a back door to get the search they couldn't get through the front door. Now, here's that phrase I promised you, and I want you to actually remember the wording, because how you phrase this matters. The moment an officer says something like, we're going to have your car towed and inventoried, you calmly respond, I'm not consenting to any search of my vehicle, and I'm asking to safeguard my own property before it's towed. That single sentence does 2 enormous things for you. First, it makes clear on the record and on any body cam footage that you never gave permission for anyone to go through your belongings. Second, it forces the officer to either let you remove and secure your own items, which many departments require by policy, or it puts them in a position where ignoring your request can later be used to show the search wasn't really about protecting your property at all, since they denied you the chance to protect it yourself. To understand why this phrase carries so much weight, you need to know the 3-part test that courts actually use to decide if an inventory search was legal in the first place. This test came straight out of the Opperman decision I mentioned earlier. The first requirement is that your vehicle has to be lawfully in police custody, meaning you were either arrested or the car was legitimately being impounded for a valid reason, not manufactured out of thin air. The second requirement, and this is the one officers violate constantly, is that the search has to follow a written standardized departmental policy. This can't be an officer making up the rules as they go. There has to be an actual document somewhere that says how these searches are supposed to be conducted. The third requirement is that the search has to be reasonable in scope, meaning the officer is supposed to be creating an actual list of items for safekeeping, not rummaging through every compartment looking for something incriminating. The Supreme Court took this even further in a case called Colorado v. Bertine. In that decision, the justices made clear that if the person whose car was searched can show that the police acted in bad faith, or that the sole purpose of the search was investigation rather than protecting property, the entire search becomes invalid. Think about how powerful that is. The court is telling us that motive matters. It's not enough for an officer to slap the label inventory on what they did. If the real reason they searched your car was to go fishing for evidence, the search is unconstitutional no matter what paperwork they filled out afterward. This exact issue came up again in Florida v. Wells, a case where a highway patrol officer wanted to open a locked suitcase found in someone's trunk during what was supposedly a routine inventory. The Supreme Court struck that search down, explaining that the department had no policy whatsoever addressing how officers should handle closed containers. Without a clear standardized policy telling officers what to do with locked items, the court said the search simply wasn't regulated enough to satisfy the Fourth Amendment. This is exactly why the phrase I gave you earlier matters so much. When you ask to safeguard your own belongings and the officer refuses, and then that officer opens a locked bag or container anyway, you and your attorney now have a direct argument rooted in Wells that the search exceeded what any legitimate inventory policy could allow. There's another case worth knowing about, United States v. Johnson, where courts found an inventory search illegal because officers labeled certain items on their report as evidence rather than simply listing them for safekeeping. If police are writing down that something is evidence rather than personal property being protected, that's essentially a confession in their own paperwork that they weren't doing an inventory at all. They were building a criminal case. Judges have picked up on this pattern again and again, and it's one of the clearest signals that a supposed inventory search was really just an excuse to dig for something to charge you with. Then there's the New Jersey case, State v. Hummel, which shows just how far some officers will stretch this doctrine. In that case, police seized a woman's purse specifically because she asked for a lawyer and stopped answering questions. She wasn't even under arrest. The court found that the seizure had nothing to do with protecting her property and everything to do with punishing her for invoking her constitutional rights. When officers later claimed they took her purse out of safety concerns, the court pointed out the obvious contradiction, since they had let her reach into that same purse earlier without any hesitation. This case is a perfect illustration of why you should never assume an officer's stated reason for searching your car is the real reason. So let's talk about what actually happens once your car is sitting at the impound lot, because there's a specific case you need to know here too. In State v. Mangold, police impounded a van after a car accident, and only once it reached the tow yard did officers show up to conduct their inventory search, discovering marijuana in the process. The court threw the search out because the driver, who hadn't even been arrested, was never given a chance to remove his own belongings before the vehicle was towed away. This tells you something critical. If police intend to inventory your car, that process is supposed to happen with you present, giving you the opportunity to protect your own items, not after the fact once your car is sitting alone in some lot with no one around to object. Now let's talk about locked containers specifically, because this is where people get caught off guard the most. If police encounter a locked glove box, a locked case, or a locked toolbox in your trunk, courts have generally said officers cannot force it open or destroy it unless there's a clearly written policy addressing exactly this situation. If an officer can't get into something and simply breaks it open, pries it apart, or smashes a lock to see what's inside, that destructive behavior itself becomes evidence of their true intent. Nobody protecting your property for safekeeping needs to destroy that property to catalog it. You can inventory a locked briefcase by listing one locked briefcase without ever opening it. The instant an officer breaks that lock, they've revealed they were looking for something, not protecting anything. This is also where your state's own constitution can become your best friend. Roughly half the states in this country have interpreted their own state constitutions to provide more protection than the federal Fourth Amendment guarantees. This is sometimes called the interstitial approach, and it means that even if federal law under Bertin would technically allow a search, your state's highest court might say otherwise. Texas is a perfect example. In Autran v. State, the Texas Court of Criminal Appeals ruled that under Article 1, Section 9 of the Texas Constitution, police need a warrant before opening closed containers during an inventory search, even though the federal standard wouldn't require one. If you live in a state like Texas, New Mexico, Massachusetts, New Jersey, Oregon, or Washington, you may have significantly stronger protections than someone living in a state that only follows the bare federal minimum. Knowing your specific state's law can be the difference between evidence getting thrown out and evidence sticking. Let's also address the gray area, because not everything in this area of law is black and white. In United States v. Lozano, officers found a small container with a pill inside and couldn't immediately tell whether it was something legal or something illegal. The court said officers do have some latitude in these situations, meaning a policy that allows opening containers when officers genuinely cannot determine the contents from the outside can be constitutional. But notice the limitation baked into that ruling. This latitude exists only when there's genuine uncertainty about the nature of the item, not as a blanket excuse to open every single thing in your car. And even with that latitude, officers still cannot rip apart interior panels, tear open upholstery, or dismantle parts of your vehicle looking for hidden compartments. An inventory search covers what's visible and accessible, not a full-blown teardown of your car. So knowing all of this, what should you actually do the moment you find yourself in this situation? Beyond the phrase I gave you earlier, there are a few more things worth saying and doing. If the officer tells you the car will be towed, ask directly whether a licensed passenger or a family member can take possession of the vehicle instead of it going to impound, because many departments' own policies say that if a valid alternative exists, towing and inventorying isn't necessary at all. Ask whether you are free to leave, because if the stop is stretched on far longer than the original violation required, that extended detention itself can become its own separate constitutional violation. If officers begin searching before you've had the chance to object, say clearly and calmly that you do not consent to the search taking place. And if you have someone with you, ask them to record the interaction from a safe distance, because body cam footage doesn't always tell the whole story, and your own footage might. Do not physically interfere with the tow or the search itself, because that alone can turn a civil rights violation into a new criminal charge against you, and that's exactly the outcome the officer wants if they were searching improperly to begin with. Instead, let the violation happen. Document everything you can afterward. Write down badge numbers, patrol car numbers, and the names of any witnesses, and take that information straight to an attorney who can file a motion to suppress based on everything we've just covered. At the end of the day, the word inventory is not magic. It is not a password that unlocks your car for police to search however they please. It is a narrow, specific exception to your Fourth Amendment rights, bound by strict rules about policy, purpose, and procedure. When officers ignore those rules, when they search for evidence instead of safekeeping, when they refuse to let you protect your own belongings, or when they destroy your property to see what's inside, they are not conducting a lawful inventory. They are conducting an illegal search wearing an inventory's clothing. And your rights only protect you if you actually know them and use them in the moment that matters most. Now that you know exactly what to say the moment police mention an inventory search, you need to know what to do if officers try a completely different trick to get you out of your car and searching it under a totally different excuse. In my next video, I break down the exact phrases officers use to manipulate drivers into consenting without even realizing it, and the simple responses that shut each one down. I'll see you there.